In this video, we will take a closer look at filing an informal appellate brief in the Minnesota Court of Appeals. This video will answer the following questions. What is a brief and when do I have to file it? What do I need to include in my brief and what should I not include? What format do I have to use? What is an addendum and do I have to have one? What happens next? And how can I get help? A brief is the term used for the written argument you present to the judge. Unless you have a lawyer, there will be no oral argument, so the written argument is your only opportunity to persuade the court. There are rules you need to follow when you write a brief. The rules are part of the Minnesota Rules of Civil Appellate Procedure. We will refer to these rules throughout this video. You can find the rules at the website on the screen and in the video description. If you are the appellant, the person who filed the appeal, you must file a brief or your appeal will be dismissed. The brief is your chance to tell the court why you think the decision you are appealing is wrong. Your brief is not a chance to retry your case or introduce new evidence. The judge can only look at what happened in the trial court or agency and decide whether there was an error. There are two different kinds of briefs that you can file. Lawyers file a formal brief, which has strict instructions about content and formatting. If you are representing yourself, you can file an informal brief. The requirements for the informal brief are simpler, and there are fewer formatting rules. You will file your brief after the court gets the transcript, or the record of what happened in the lower court. Once the court gets the transcript, you have 30 days to file and serve your brief. If there is no transcript, or if you already got it before you filed your appeal, you have 30 days from the date you filed the notice of appeal. Rule 131.01 allows you to add 3 days to your time to file and serve your brief if the court reporter mails the transcript. You may want to talk to an attorney about what your deadline is to make sure you don't miss it. You can ask the court for more time to write your brief. Rule 131.02 lets you file a motion to extend the time to file your brief. You will need to file and serve the other party with this motion before your deadline. The state law library has a motion form you can use to ask for more time. Your motion should tell the court why you need more time, how much extra time you are asking for, and what the benefit of the extra time will be. The court will make a decision based on the reasons you listed. For example, you do not have an attorney, you are having surgery, your workload is too much for the weeks before your deadline, etc. The court may grant or deny your motion. The court could also grant your motion, but give you a different amount of time. For example, you asked for 60 extra days, but the court gives you 30 extra days. Your informal brief should include your legal arguments and an addendum. We'll talk about the addendum later. The State Law Library has created a template you can use as a guide for writing your brief. We'll break down each piece individually. You don't have to follow this exact format, but these sections can be useful for structuring your brief. The main parts of a brief are statement of legal issues, statement of the case, statement of facts, argument, and conclusion. The most important section is the argument. The statement of legal issues is where you can write what issues you want the Court of Appeals to review. Write down each issue and a short statement of how the trial court decided that issue. For example, did the trial court correctly calculate income when deciding child support? The trial court decided I am self-employed and make $2,000 per month. The statement of the case is a short paragraph about what happened in the lower court. For example, this case involves a child support dispute. On May 1, 2019, respondent asked the court to establish child support for our minor children. On July 8, 2019, the trial court found that appellant is self-employed and makes $2,000 per month and set child support at $300 per month. On August 5, 2019, appellant filed this appeal. The statement of facts is a short summary of the facts of your case related to the issues you are appealing. For each fact you include, you must point to the place in the transcript, district court record, or addendum where that fact appears. For example, appellant received a letter from the department on June 18, 2019, addendum 1, or respondent told appellant that there was an agreement, transcript 34 to 35, or appellant made an offer to pay $150 per month in child support, Doc 11 at 3. You can find examples of how to do this for different types of documents in Rule 128.03. Remember, you can't bring up any new evidence or talk about things that weren't discussed in the trial court. You can combine the statement of the case and the statement of facts if you want. Your argument will probably be the longest section of your brief, and it is the only section you must include in your informal brief. You need to present a legal argument to support your case. This means you will need to do legal research and include citations to cases and/or statutes that support your argument. For example, the district court should not have concluded my income is $2,000 per month because that amount includes my business expenses. Under Minnesota Statutes 518A.30, income from self-employment is defined as gross receipts minus costs of goods sold minus ordinary and necessary expenses required for self-employment or business operation. The court should have subtracted the cost of phone and internet service because it is an ordinary and necessary expense required to run my online store. Because the district court miscalculated my income, it ordered me to pay too much child support. The Court of Appeals has ruled that if you make conclusions without analysis and citations, they don't have to consider your argument. This means you need to explain your reasoning using the law. The State Law Library has examples of informal and formal briefs that you can look at to understand how to create your brief. The State Law Library can show you how to search for statutes and cases and how to use them, but you will need to do your own research or hire an attorney to help you. Finally, the conclusion is a sentence or two that says what you want the court to do. For example, I ask this court to reverse the trial court judgment against me. Remember, your brief is not a place to provide new evidence or talk about things that were not addressed at your trial. You will need to cite to the record for everything you want the court to consider. This means you need to refer to the transcript of the trial. The Supreme Court has decided that the court can't base its decision on things that are not part of the record from the lower court. You don't have to follow the strict formatting rules lawyers do, but there are a few things you should keep in mind. If you type your brief, you should use an easy-to-read 13-point font, such as Times New Roman or Arial. You will also want to make sure you put a cover sheet on your brief that has the case caption. For example, John Doe, appellant versus Jane Smith, respondent, and the case number, for example, A99-1234. This is how the court knows which case the brief goes to. You can find this information on any documents you receive from the court in your case. You will also want to include your name, address, and telephone number on the cover sheet. You will need the same information for the other party or their lawyer. Finally, you need to sign your name at the end of your brief. Your brief can't be more than 45 pages, but this doesn't include your addendum. Rule 130 requires you to include an addendum for your brief, even if you are filing an informal brief. The addendum must contain the order, judgment, or findings of the judge that relate to your appeal. This means you must include a copy of the order you are appealing. You may be thinking that you already filed a copy of that order with your statement of the case. Even if you did, you still have to put this order in your addendum, or the court can reject your entire brief. If you do not have a copy of this document, you can get a copy from a court records terminal at any Minnesota courthouse if the case you are appealing happened in district court, like a family law or civil case. For many case types, you may be able to get a copy through Minnesota Court Records Online, also known as MCRO. You can access MCRO through the court's website or using the link in the video description. If you are appealing a case like an unemployment decision or a disqualification from the Department of Health, you can get a copy from the agency or department that issued the order. You can contact the state law library if you are not sure where to find the order or judgment. You can also include up to 50 more pages of documents from the record or statutes, rules, and cases you think would be helpful for the court to have while reading your brief. Keep in mind that the Court of Appeals will get access to the exhibits and documents filed in the trial court, so you don't need to include everything. Remember, you can't use the addendum to present new evidence. After you have written your brief, you will need to fill out the Certification of Length of Document form. You can get this form from the State Law Library. The form asks you to confirm that your brief follows the rules and to give information about the font, length, and software you used for your brief. Next, you need to make copies so you can file and serve the brief, addendum, and certification of length of document. You will need one copy of your brief for every other party in your case. You will need one copy of your brief to file with the court. You should also keep a copy for yourself. This means you will need at least 3 copies of your brief and addendum. If there is more than one other party, you will need more copies. Once you have made your copies, you need to serve the brief. Service means giving your court documents to the other parties in your case. You can have someone else who is over age 18 do this for you in person, or you can mail it to the other parties. You need to do this before your deadline, or your brief will be considered late. After you serve the other party, you need to file a certificate of service with the court. You can find that form online or at the State Law Library. You also need to file your brief and addendum with the court. Filing means giving your documents to the clerk of appellate courts. You can file in person, by mail, or by e-filing. If you decide to use the e-filing system, you have to use the system for everything else you file. After you file and serve your brief, the other party in your case gets a chance to file a brief. The respondent does not have to submit a brief for the case to go forward. If the other party files a brief, they have 30 days from when they were served with your brief to file. If the other party's brief brings up a topic you did not cover, you are allowed, but not required, to file a reply brief. You have 14 days from when you got the respondent's brief to file and serve your reply brief. If you were served by mail, you have 17 days from the date the brief was mailed. Your reply brief can't be more than 20 pages long, and you can only talk about the new issues the respondent included in their brief. Just like your opening brief, the reply brief should be focused on legal argument. If you are appealing to the Court of Appeals, a 3-judge panel will decide your case. The court will tell you who the judges are and when they will be considering your case. If you do not have a lawyer, the judges will consider your case without oral argument at a conference. Most people think they will have a chance to speak to the judges like they do in a trial court, but that is not how the appellate courts work. The judges have 90 days after the conference to issue their decision. The court will send you a copy of the opinion in your case. You should know that all appellate court opinions are public and will also be available on the Judicial Branch website. This may mean that the opinion in your case will turn up if someone searches for you online. The appeals process can be complicated and confusing. The Minnesota State Law Library can help you understand the steps involved and help you find resources to make your case. You can get advice from an attorney at the Appeals Self-Help Clinic, held from 1:30 to 4:30 on the 3rd Thursday of each month. You can find more information about the Appeals Clinic on the State Law Library website or by calling 651-297-7651. The State Law Library also has a guide for writing appellate briefs with links to templates and helpful resources. You can always call, email, or visit the Law Library for help. The law librarians cannot write your brief for you, but they can help you find cases and statutes. You may also decide you want to get a lawyer to help you. You can search for lawyers using the MN Find a Lawyer directory at www.mnfindalawyer.com or the Minnesota Lawyer Referral and Information Service at www.mnlawyerreferral.org. Thank you for watching this video. Remember, you can always contact the Minnesota State Law Library if you have questions.